All right, committee, we will go ahead and get started today. Welcome everyone here. We are going to begin by opening the hearing on House Bill 2657 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2657 would enact the Reduce Armed Violence Act to increase criminal penalties for certain violations of criminal possession of a weapon by a convicted felon when that possession involves a firearm. The bill amends KSA 216804, that's the sentencing guidelines for non-drug crimes. This bill would add a new special sentencing rule to provide that when a person is sentenced for a violation of criminal possession of a weapon by a convicted felon, that sentence for that violation would then be presumptive imprisonment. It would be served consecutively to any other term of imprisonment imposed if the trier of fact makes a finding beyond a reasonable doubt that the weapon the offender possessed during the violation was a firearm and that firearm was possessed by the offender during the commission of any violent felony. For the purposes of this special sentencing rule, a violent felony would include capital murder, murder in the first degree, murder in the second degree, voluntary manslaughter, aggravated assault of a law enforcement officer, aggravated battery of a law enforcement officer, kidnapping, aggravated kidnapping, robbery, aggravated robbery, rape, aggravated criminal sodomy, abuse of a child, burglary, aggravated burglary, arson, aggravated arson, treason, any drug felony, felony criminal discharge of a firearm, fleeing or attempting to elude a police officer, aggravated endangering a child, mistreatment of a dependent adult or mistreatment of an elder person, any felony that includes a domestic violence designation, and then any attempt, conspiracy, or criminal solicitation for any of those offenses listed above. And I can take any questions.
I think maybe you should have just listed the ones that weren't applicable. It might have been a shorter list. Thank you, Natalie. Committee questions? All right, not seeing any. Natalie, thank you. We'll now hear from the proponents and welcome Derek Schmidt, Kansas Attorney General. Derek, thanks for coming.
Thank you, Mr. Chairman and members of the committee, and thank you for having this hearing. I think it's the first time I've appeared in front of your committee this year, so I appreciate the opportunity. Mr. Chairman, you all have the written testimony. I, of course, won't read it. Let me just maybe describe what and why we think we're doing here. So, we've had the opportunity at our office to work with a lot of law enforcement agencies and a lot of prosecutors around the state for a long time. And there is one consistent theme that we hear, there are probably several, but there's one relevant here, and that is that there seems to be this particular core of individuals who continually use firearms repeatedly to commit violent crimes in our communities. And if only we had a more effective tool in state law to deal with some of these folks, particularly if we get to them before somebody gets terribly hurt, the safer our communities will be. That's the basic concept. Mr. Chairman, just for me individually as a philosophical point, I know you have been, as have others here, been very invested in the criminal justice reform process, which I've been a great supporter of and appreciated your service. It does seem to me we might be at a point in time where having this discussion makes logical sense because of that discussion. That is to say, we've made a lot of progress in advancing the basic concept that there are individuals who historically have been imprisoned who instead their misbehavior ought to be dealt with otherwise, substance abuse treatment, mental health interventions. That's what the active focus of the criminal justice reform has been. I certainly believe that's true. The flip side of that same coin is there are individuals on our streets who, in my view at least, keep committing violent felonies against other people, and they ought to be removed from society, and we have the capacity to do that, sort of a hand-in-glove fit. So that's the spirit in which this is brought, and that's the concept of the policy that we're trying to advance. The mechanics of what we suggested, we looked at several different options, and what you have in front of you is our suggestion to do this by a special sentencing rule. We deliberately didn't create any new crimes or define any new misconduct. That is to say, the universe of people affected by this are by definition already committing a felony under current law, and that's the felony of possession of a firearm by a felon. We're not expanding the universe, we're not shrinking the universe, we're not changing what they have to do to run afoul of that law. What we are suggesting is that if you are a person who under current law has a prior felony, that felony disqualifies you from possessing a firearm, you nonetheless possess a firearm in violation of current state criminal law, so you're already committing another crime, and this is the substantive addition, you possess that firearm at a time when you are committing another violent felony. That the purpose here is to make sure that the sentence for the crime of illegally possessing the firearm doesn't just get lost or subsumed either as probation or within whatever the consequence of the other crime is you've committed. So that's the theory and the approach behind presumptive imprisonment sentence as opposed to presumptive probation and consecutive as opposed to concurrent. Mr. Chairman, I think that's it. The only other thing I might add is Natalie was reading the list. It occurred to me I might explain where that list of violent felonies came from because I recognize that it's a little bit long and unwieldy. We were looking for a list of violent felonies in current law we could just reference, and we didn't really find anything suitable. So what we did to come up with the list that Natalie read to you, we took the list of inherently dangerous felonies in the felony murder statute. We struck a couple that just to us seemed logically inapplicable here, like endangering the food supply, for example, we struck out of there. And then we added the domestic violence designation category as well. And that's where that list came from. That's how we created it. So, Mr. Chairman, that's what we have. I'd either be glad to stand for questions or sit down. I know you have other conferees. I'll be here through the hearing. So.
Oh, certainly. We do have questions. Representative Wheeler.
Thank you, Mr. Chairman, and thank you, General, for being here today. As Natalie was going through her explanation, there was a mention if a judge finds this element beyond a reasonable doubt. And I'm curious about that. If this is a jury trial, will that be an element in the instructions that a jury must find?
Representative, I believe the answer is yes. The actual language in the bill, it's on page 10, line 13, is if a trier of fact makes a finding. So if it's a bench trial or a jury trial, and yes, I would anticipate that it would be in the jury instructions in the event that.
Okay, I wanted clarification on that. And then one more, because the offenses were gone through rather rapidly, which we all appreciate, but was possession of drugs in there?
I don't believe it is, but I could be mistaken.
Well, then we'll kind of let me get back and I'll read it again myself.
Thank you, Representative. And as I just would underscore, we, or at least I, we're not wedded to this list. We had to have a list in order to get that qualification for the enhancement. We got this list the way I just described. If there's a better public policy way to tweak it, that causes no concern on my part.
Well, I just wonder about possession, but then on the other hand, if it's possession of fentanyl, that's a different deal. Thank you, General.
Thank you. Additional questions. Representative Heiberger.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for being here. I appreciate your dedication to public safety. I wish I shared your optimism about how much progress we've made on criminal justice reform. But do you recall a bill last year, I believe it came from your office, it's HB 2058, otherwise known as the Kansas Protection of Firearms Rights Act?
Representative, not off the top of my head, but I don't doubt it. I haven't.
Well, let me just talk about one of the provisions of that, which was it changed the existing law so that a person prior to July 1, 2009 who committed an act in possession of a firearm rather than using a firearm for a crime was no longer guilty of criminal possession of a weapon by a convicted felon. Do you recall that at all?
Representative, I don't. We'd have to go back and take a look at it.
Okay. I guess I was going to. Is there anybody else from your office who could answer that here?
Yeah, I just checked and. Is that ours? I don't remember. Wasn't our bill. My friend Jennifer reminds me it's not our bill, and that's consistent with my memory, but I'd sure want to double check it, Representative, because I.
That's fine. But if it was not your bill, then I would drop that line of questioning.
But I'll double check. If it is, you know, we'll change our plea, but I don't recall it. Yeah.
Thank you.
Additional question. Representative Osman.
Thank you, Mr. Chairman. Thank you, Attorney General, for being here. I have wanted to find out, would you be able to provide a list of of these particular crimes, the sentencing grade that is currently stands and the sentencing grade that you're proposing, so that I can understand what the ramifications are of this bill?
Representative, we can, and I think, to be clear, we don't propose to change anything in the grid. The grid remains untouched. What we propose is to add on top of whatever the grid sentence would be for an individual convicted of this crime in these circumstances, a special sentencing rule that just says whatever your number is on the grid that the judge gives you, you wind up doing it presumptive imprisonment and consecutive, as opposed to now when there's more discretion on that. I think, and if this is not fully responsive, I'll be glad to try to find what you need, but I think the bed space impact that I presume you all have has that information on it in terms of numbers and the assumptions they've made. But if that's not sufficient, let me know and we'll try to find what you need.
Okay. All right. Thank you very much.
You bet.
Additional questions, committee? All right, seeing, Representative French.
Thank you, Mr. Chairman. Thank you, Attorney General, for being here. I agree with you. I think since I've been here, we've been focused on criminal justice reform, and I think that was the right way to go. But I'm afraid we're approaching the extreme of that and maybe needing to recycle some of actual punishment of the criminals that really do threaten this society. So I'm kind of for this bill. I think it's going to be a good bill. Thank you.
Thank you, Representative.
Thank you. Any other questions for the general? All right, thank you, sir. We'll now welcome Mike Kagay. Hopefully I got that right. Shawnee County District Attorney's Office.
Good afternoon,
Thank you.
Chairman Owens and members of the committee. Thank you for the opportunity to be here. The only time I ever have to pull down the microphone is if I'm speaking after the Attorney General. Otherwise, it's going the other way.
We understand.
I'm not going to rehash what I've already provided to you in my written testimony, but I think it's vital that this bill receives favorable consideration from this committee. We are engulfed in a wave of violent crime around the country and around the state. Here locally in Topeka, we've had some success over the past year in directly addressing some of that. But it remains a constant. And looking at the numbers over the last couple of years, I can tell you the number of violent offenses committed by felons who are prohibited from carrying a firearm just within my jurisdiction here in the 3rd Judicial District is between 35 and 40 every year. And when I've had the opportunity to engage in conversation with some of these individuals, the reasons behind their thinking becomes clear. They have to carry a gun for their own protection. They don't care that it's prohibited by law because they know, even if they're arrested and prosecuted, the end result is going to be a slap on the wrist. It's going to be probation. So if it's necessary in their minds to carry a weapon in order to perpetrate their activity and to protect themselves from like-minded people in the community who are also violating the same law, it's a simple analysis for them. Which one is more risky, right? They're going to carry the gun. They know they're going to get probation. They almost always get probation. And even sometimes when they're in A or B history and they're presumptive prison. Because the message that the courts have taken from the application of this law is that, it's just possession. It's been a source of frustration for me for several years, and I'm grateful for the leadership of the Attorney General in bringing this bill before you. I want to tell you about 3 young ladies who lost their lives. Demaya, who is age 13, Lily, who is 5 years old, and Kiana, who is 17. They were all completely innocent and blameless of any wrongdoing. But their lives were taken because someone was carrying a firearm that they were legally prohibited from possessing. I agree with the General's assessment. I think Criminal justice reform is fantastic, and I think we have an ongoing duty to always look at ways to improve the system. But if a violent repeat felon who is completely flaunting our laws and continues to violate them and to harm others, including innocent people, does not belong in prison, then who does? Thank you again for this opportunity. I'm happy to take any of your questions.
All right, thank you, sir. Committee questions for Mr. Kagay. Representative Heiberger.
Thank you, Mr. Chair. If someone, could you refresh me on the law? I'm not a prosecutor, I don't know this. Someone now is convicted of committing a crime while carrying a weapon but not using the weapon. Is that person guilty of criminal possession of a weapon under 216304?
Yes, if they're prohibited under the statute, yes.
Okay. But my understanding is the law for people prior to July 2009, after the change you made last year, those persons are not if they just used a firearm rather than, if they were just carrying a firearm rather than used a firearm. Is that?
I don't know if I understand your question.
Okay. Under the law that we passed last year, this 2058, it changed the law so that someone convicted of violation of the Controlled Substances Act, and they were using a firearm, they were carrying a firearm but not using a firearm, they are no longer subject to being guilty of criminal possession of a weapon by a convicted felon.
I'd have to review the language of the statute.
Okay. All right, thank you.
Thank you. Representative Carmichael.
Thank you, Mr. Chair. First, I might ask, can you see me now?
We can see you, sir.
I apologize for yesterday. I didn't realize that you did without my smiling face. If I might, if the Attorney General is still there, I've had time now actually to think about what I really wanted to ask him. I think he indicated he'd still be present if you'd permit.
Certainly. Was there any other questions for Mr. Kagay at this time?
No, I want to ask questions of the Attorney General.
I know, but I wanted to see if there were any other questions for the
I
gentleman standing
apologize.
there first.
I apologize, certainly. Thank you.
All
I'll
right.
be patient.
Representative Howerton first, then we'll come back to you, Representative Carmichael.
Thank you, Mr. Chair. I just wanted to thank you for your testimony. It's heartfelt and you're very passionate and you've probably seen some really hard things along with the police officers in the room. So thank you.
Thank you. Thank you, Mike. Mr. General, you'd like to stand back up. Representative Carmichael has a question for you.
And Mr. Chairman, I think I might be able to shed some light on Representative Heiberger's question, having now refreshed my memory, if that's helpful as well.
Okay.
Let's
very
turn to
good.
his question first, Mr. Chair, if possible.
Yeah, go right ahead.
Yeah, I have now refreshed my memory. It is correct that House Bill 2058 last year was an Attorney General's bill. That was the concealed carry reciprocity bill that we'd tried for several years. The provisions that you're talking about, Representative, were not in the original bill that we brought. They were added as amendments in the process, and they were not our amendments. So,
Very good. Thank you. Now your questions, Representative Carmichael.
Thank you, Mr. Chair. I appreciate your indulgence. Good afternoon, Mr. Attorney General. When I heard through the press that you were introducing this legislation, it caused me to ponder just a little bit about what is truly the best way for us to deal with the proliferation of firearms crimes, and particularly by felons and others who clearly shouldn't have a gun. And I recognize that this might be one tool in the armament, if you will, of the prosecutor, but sadly, of course, it's after the fact. It's after the firearm has been used or possessed by the felon and more people have been injured. And so I was thinking philosophically, Mr. Attorney General, and I do respect your opinion. Could we perhaps more effectively fight the proliferation of firearms in the hands of people who shouldn't be holding them and the use of firearms by people, while they have a right to hold the firearm, in a fit of anger do very foolish things? Would we be perhaps wise also to take a careful look at the stand your ground laws, such as have impeded my district attorney in a different context.
Representative, if we could stick to the subject of this bill, that would be appreciated.
Not involved, certainly not. The question, the subject of this bill is how do we control firearms in the hands of bad people? So
That is not the subject of this bill, Representative.
and this bill would be even amendable to do some of these other things. So I would appreciate the opportunity to hear the Attorney General's thoughts.
If you have a question regarding this bill, you're welcome to answer it. If not, we'll conclude your questioning.
Let me rephrase my question. Would you recommend that we amend this bill by repealing the stand your ground laws and by limiting the number of people who can lawfully carry firearms?
Mr. Chairman, my answer to Representative Carmichael's question would perhaps unsurprisingly be no. I would not recommend that you amend this bill in that way. I have said previously publicly, as I think have some members of this committee, that I think it would be worthwhile for the legislature to take a review and another look at the structure of Kansas' current self-defense laws to be sure that as they've been interpreted by the judiciary, they are functioning in the manner that they were intended. But I wouldn't recommend doing that on this bill.
Thank you. Additional questions, committee? Thank you, Mr. General.
Thank you.
All right, we'll now be pleased to hear from Tony Moe, President of the Kansas Gang Investigators Association, and Jamie Miller, Region 1 Representative of the Kansas City, Kansas Police Department. Gentlemen, welcome to committee.
Chairman Owens and members of the committee, thank you for allowing us to provide testimony today in favor of House Bill 2657. We are here on behalf of the Kansas Gang Investigators Association, also known as KGIA. I've been with the organization for 15 years and have been the president for the last 7 years. I'm a retired master deputy with the Johnson County Sheriff's Office and have 25 years of law enforcement experience.
And my name is Jamie Miller. I'm a detective with the Kansas City, Kansas Police Department and a member and a representative from Kansas Gang Investigators Association. I've been with the Kansas City, Kansas Police Department for 17 years and have been working gangs for 7 of those years. And I'm also here to represent our department on this matter as well.
We're requesting your support in legislation today because it fixes the gap we have with our current sentencing guidelines. Sentencing felons to probation only instead of prison time is not the deterrent needed to restore the safe streets that the citizens of our communities in Kansas deserve. Law enforcement continues to combat gun violence in communities across our state. Career criminals are able to threaten violent acts using firearms and avoid prison time due to the current sentencing guidelines, even though our current law prohibits felons from possessing firearms. The number of repeat offenders is overwhelming. According to the statistics from the Wichita Police Department, the number of felons being arrested for firearm possession doubled between 2015 and 2021. And as of this year already, there's 28 documented cases.
Speaking for Kansas City, Kansas on that, I can tell you our numbers are kind of skewed because of our record management system. When we were learning it, it didn't cover a lot of the federal charges that came through, or if that charge was amended later on throughout the case. But so far this year, we have already had 46 felons caught in possession with firearms. And just to put that in kind of relative terms, Kansas City, Kansas is about 150,000 people as opposed to 300 and some in Wichita. So our city is really going through it right now.
The need for a second chance for individuals who choose to steer their lives in the right direction is not lost on members of law enforcement. This law affects only career violent criminals. It is common knowledge amongst the gang community that being caught with a firearm only results on a slap on the wrist or more probation. Those individuals who choose to continue to commit crimes and cause violence have taken advantage of the current laws. These career criminals will continue to use the system to continue to commit more violence in our communities. As a member of law enforcement, we work very closely with criminal street gangs, their families, and the victims. We hear repeatedly that they feel they have to carry a gun, join a gang, or shoot someone because they don't feel protected by the justice system. This creates an entire new generation of people willing to use firearms to commit violence. We need a stronger deterrent. Once word gets out that carrying a firearm results in incarceration instead of probation, we believe the numbers will decrease. As many of us are parents ourselves, we strive for our children to live in a safer society. As law enforcement professionals, we believe this is a significant step in helping achieve those goals. Thank you, sir.
Thank you. Committee members, questions for these gentlemen. Representative Resman.
Thank you, Mr. Chairman. I've known Tony for a number of years and worked with him at the Sheriff's Office. Really good guy. My question is this going after just strictly gangs, or is this going to encompass?
No, it's career violent criminals, basically. We are just representing the gang investigators of Kansas.
Thank you. Additional questions, committee? Representative Howerton.
Thank you, Mr. Chair. I'm not sure who this would be directed to. Maybe you could help me in that. I'm just curious where, like historically, where did this attitude of the courts come from? Is there a reason, or is there an explanation, or just to give probation instead of? And you may not know that, and
I don't know that, I'm sorry.
Okay.
Yeah, that's something we could talk about. Looking back in history, the sentencing grid, probation boxes, things like that have changed over time.
What it is, okay.
And so, yeah. Representative Wheeler?
Thank you, Mr. Chair. Gentlemen, thank you very much for your testimony. I'm interested in well, I want to predicate this. I'm from Garden City. When I became county attorney there, we had a horrible street gang problem. Gangs are a little different, I think, nowadays than the street gangs. But your comment that gang members are joining gangs because they don't feel protected on the street. And am I correct in assuming that they don't feel protected from other gangs, or is it from law enforcement who now is suffering the attacks of these people yourself?
Yes, sir, I find that in my career and in situations where I start talking to kids probably when they're in 5th or 6th grade and they start getting involved in gangs. And I see young men and women slowly progress from kids who are scared, I don't want to get involved in a gang, to my big brother's in one, to where I started carrying a gun because so-and-so was carrying a gun, to where now they're committing acts of violence. I found that throughout my career, you see a small percentage of actual gang members who are the ones that go out and say, I'm going to go find somebody from an opposing gang and I'm going to shoot them today. If they are able to find them, these young men and women are afraid that, hey, if I don't carry a firearm, then I'm gonna get, somebody could take my life. And I know that this person's not scared to carry a firearm because they've been caught with guns so many times in the past and they're still back out here on the streets. And what we found is, and we kind of touched on it, is that eventually these young men and women who start carrying a gun because they're scared get put in situations where now they're starting to use firearms, and now they aren't afraid to use firearms, and then they take the next step to now they're aggressively using firearms. So if we could, this bill, I think, would help us maybe prevent some of these younger kids from feeling the need to carry a firearm, because some of these more hardened criminals or people that are aggressively going out and causing violence, they might be less likely to carry a firearm because of this bill.
Thank you, sir. And we found that recruitment began at about 5th grade. It's very chilling.
Yes, sir.
Thank you. Additional questions? Representative French.
Thank you, Mr. Chairman. You mentioned career criminals. When does a criminal become a career for them? Is there a point where there is no going back, as far as you know? Just your opinion, I understand, not anything official.
My opinion only. Once they've committed violent acts towards others, they're starting their career as a long-running criminal at that point. Whether they sell drugs, human traffic, things of that nature, they've chosen that career instead of a law-abiding one.
So it doesn't take multiple events, you just, if they murder somebody, then they are a career criminal for the rest of their lives? Is that what you're saying?
No, I'm not saying that. There's always reform. People can reform, but it is in my knowledge base that I worked in the Johnson County Jail for most of my career. And the recidivism rate at that point, I could tell I was not only going to get that person back, but I'd probably get their children back as well. So it's multi-generational sometimes.
Do you have a comment?
Yes, sir. And I think that we're using a term that I know is defined in certain statutes, but I think we're using it more as a term for people who have made a decision to actively continue a career path, and that being that they're committing crimes. I've dealt with people that have done, 5 or 6 felony crimes or 1 or 2 that seem to be like on that path, and I'm not going to get off this path unless something causes me to get off that path. And our goal is, to address these young men and women and hopefully be able to steer them in the right direction initially. But if they're not going to get off that path on their own, then to avoid having them perpetrate violence against others, I think that's why we're referring to them as career criminals, so that then maybe incarceration might encourage them to get off that path.
Thank you for being here. Thank you, Mr. Chairman.
Certainly. All right, seeing no other questions, well, thank you, gentlemen, very much. Members, I will submit multiple pieces of written-only proponent testimony. Instead of reading them all, I'll just tell you to check your agenda because there's quite a few. Is there anybody else here to speak in person as a proponent? Or any neutral conferees today? All right, then we'll move to our opponent testimony and welcome Clayton Perkins with the Kansas Association of Criminal Defense Lawyers. Clayton, welcome.
Thank you, Chairman and members of the committee. And I am here today as an opponent not of the broad policy goals that I think are behind this, including the noble goal of reducing armed violence in Kansas, particularly for repeat offenders who have, it sounds like, even been convicted of possibly being a felon in possession of a firearm multiple times. I'm here really more concerned with some of the technical aspects of how this applies and the sort of broadest extent to which this applies. And I think it's good to start off with a reminder of where we are in Kansas sentencing law here, because we already have multiple special rules relating to crimes committed with firearms and those sorts of things. To begin with, this bill sort of does 2 things. It makes a sentence for being a felon in possession of a firearm mandatorily consecutive to another sentence. And it makes it presumptive imprisonment rather than presumptive probation when convicted of a violent felony as defined under the law. So you sort of, I want to drill down on where we already are on Kansas law for that, right? So these would be cases where you already have 2 convictions. In those cases, a sentencing judge already has discretion to determine whether or not a crime is concurrent or consecutive. So whether that sentence will be served at the same time for multiple convictions or one after the other. This makes this mandatorily consecutive. The second thing this does is makes it presumptive imprisonment, which is a little interesting under the structure of this bill, because this requires 2 crimes, right? Felon in possession of a firearm and a violent felony. The vast majority of the violent felonies, like murder particularly, are already presumptive imprisonment crimes. And when the primary offense, which is the higher severity level one, which is virtually all of the violent crimes in this list, in this bill, when you're convicted of that, that's the primary offense. So that controls whether or not you are presumptive imprisonment or probation already. We also have special sentencing rules, such as in 216804, which is what this bill is amending. We already have a special sentencing rule under subsection H. If you commit a person felony with a firearm, that's already presumptive imprisonment. And also, even for low-level crimes under our sentencing grid, if you're in the A or B box, which are the highest criminal history scores, so you have multiple prior person felony convictions, you're already outside of presumptive probation range for low-level offenses. So when we are sort of drilling down, particularly on this probation change, on who is impacted, it's going to be people on the lowest severity level of the crimes of this list with lower criminal history score, the lowest criminal history score, who were not committing a person felony with a firearm, which is a relatively, or like, those are the cases where I think courts are in the best position to exercise discretion and look at the individual characteristics of what was going on in that particular crime, and where mandatory imprisonment and mandatory consecutive sentencing will have the most impact and most concerning impact. Because if you are running a felon in possession of a firearm conviction consecutive to, say, letter A in this list, capital murder, that is a crime that carries either the death penalty or life imprisonment without the possibility of parole. So the 8 to 27 months that will get added onto that don't have very much impact. But at the furthest down of this list, where we're getting to drug possession, which is under category subsection U, and that's statute KSA 215706, that's looking at changing a person from a presumptive probation to a mandatory prison term that's going to be at least, I believe, 17 months. And the other thing to keep in mind with this crime of being a felon in possession of a firearm, which is KSA 216304, is that there are offenders who are repeat offenders who are clearly aware that they are prohibited from possessing a firearm in Kansas. But there are also people who are caught up in some of the technical requirements of this statute and can even be unaware that they are prohibited from possessing a firearm in Kansas under this statute. The sort of classic example of this is someone who has received a suspended imposition of sentence in Missouri, which is generally not considered under Missouri law to result in a conviction. So then you're not a convicted felon in Missouri. And federal law also follows the Missouri rule that suspended imposition of sentence doesn't result in you being a convicted felon. But under Kansas law and our definition of conviction, that is considered a felony conviction. So people unwittingly and unknowingly have gotten caught up and in fact get charged in sort of our border areas with Missouri relatively frequently with being a felon in possession of a firearm because they have a firearm which they can legally have in Missouri and under federal law, and they didn't realize that they're still prohibited under Kansas law from having that. Also, the way this statute works is our various time frames trigger off of things like whether it was a person or non-person conviction versus a drug conviction that all have different time frames on there. And particularly when you're dealing with people who might have out-of-state convictions, they may not realize that they have a person conviction subject to 3 years of not having a firearm as opposed to a non-person conviction subject to 3 months of not having a firearm. So there are people here who are not repeat offenders in that sense, like we've been talking about today, who can get caught up in this sentencing scheme. And the thing the example in my testimony that's the most concerning to me is with both the drug crimes and particularly simple drug possession on this list. You can have someone who had a Missouri suspended imposition of sentence for some prior thing and has 2 municipal marijuana convictions who lives in Missouri but goes on a hunting trip in Colorado. And they take their hunting rifle with them, which they can legally have in Missouri and under federal law. And when they come back and they forget that they kept some amount of marijuana that they legally purchased in Colorado, if they get pulled over, arrested, a drug dog comes by, that third marijuana conviction is a felony. And then under this, because under Kansas law, they'd be a felon in possession of a firearm, this consecutive sentence would put them in prison mandatorily for 17 to, depending on where they fall on the grid. And that's really the core of my concern with this. And so even if this statute goes forward, I don't know that the goal is served by including the drug crimes in subsection U on here, and especially simple possession in KSA 215706. And my other comment, which is also extremely technical, I think we need to look at subsection V here, which is a reference to KSA 216308A or B. And I think there's something there that's wrong, because that's referring to the entirety of that statute and includes like a misdemeanor and that kind of stuff. And I'm thinking there might be like an A1A that needs to be in there, is based on, I guess, in the intent. I'm happy to stand for questions.
Thank you, Clayton. We'll certainly take a look at that, that reference you made. Committee, are there questions for Mr. Perkins? All right, seeing none, thank you very much. Committee, now we'll hear from Nick Reinecker, who's a private citizen on WebEx. Nick, welcome to the committee.
Thank you, Mr. Chairman. Can you hear me okay?
I can.
Very well. Thank you, Mr. Chairman and committee members, for allowing me to speak today. My name is Nick Reinecker, citizen from, private citizen of Kansas. I won't go into any commentary except to say that I agree with some of the testimony from the previous opponents. As I was reading this bill, as I was going down the list, I was checking them off. I was like, yep, that's good, that's good. And then I got down to the Z3U and section AA as it pertains to U, involving any felony offense described in KSA 2021, 5703, 5705, and 5706. 5705 and 5706 is the ones that I have a problem with, involving the unlawful cultivation and unlawful possession. And as most of you know, I'm for mandatory minimum sentences when it comes to methamphetamine, crack cocaine, any type of chemical substance like that of synthetic form. But when it comes to the natural plant cannabis, this is my hill and I'm willing to die on it. I would be happy to change from opponent to proponent if cannabis as the natural plant, regardless of THC content, was descheduled from the State Controlled Substances Act. I would then put my application in somewhere at a law enforcement agency and try to get on and be a law enforcement officer again, without having to worry about the discretionary practices of cannabis enforcement. Again, I could go on to some commentary, but in the sake of unity and for the sake of respect of the process, the committee, the legislative process, and all of you good people doing your work, I will bottle my commentary and just leave it at that. I thank you so much for allowing me to speak today, and I'll stand for any questions.
All right, thank you, Nick. Any questions for Nick, committee? All right, seeing none, thank you for your time. All right. Is there anybody else here to speak in opposition to House Bill 2657? Seeing none, we'll go ahead and close the hearing on House Bill 2657 and move on to the hearing on House Bill 2673 and ask Natalie to provide us an overview.
Thank you, Mr. Chairman. House Bill 2673 would expand the number of presumptive probation and border boxes on the sentencing grid for drug crimes. So current law in KSA 216805 provides that grid blocks 5C, 5D, 4E, 4F, 4G, 4H, and 4I are border boxes, which you can see, those are the ones with the hash marks on your sentencing grid. This bill would change grid block 5B from presumptive imprisonment to a border box, and 5D from a border box to presumptive probation. Grid blocks 4C and 4D would change from presumptive imprisonment to border boxes, and then grid blocks 4G, 4H, and 4I would change from border boxes to presumptive probation. Section 2 amends KSA 216824. That is the Certified Drug Abuse Treatment Program. We typically hear it referred to as Senate Bill 123 treatment, to allow more people who would now possibly be sentenced to probation under the new grid to participate in that Certified Drug Abuse Treatment Program if they are sentenced to probation. So offenders in grid blocks 5A and 5B would be allowed to be sentenced to the program without a finding the safety of the public would not be jeopardized. And then offenders in grid blocks 4C, 4D, 3G, 3H, or 3I would become eligible if the court does make that finding that the public would not be jeopardized. And I can take any questions.
Questions, committee? Representative Rissman.
Thank you, Mr. Chairman. Didn't we have a bill last year similar to this?
You did. It was House Bill 2146, and perfect, yes. So that bill had a slightly different, it did expand the probation and border boxes in a slightly different way. And then you guys, when you worked that bill, you amended it to include the grid that's before you today. So this bill that you have incorporates all the amendments that you made to that bill last year.
So that's really the only change in the bill is the grid boxes?
The boxes, and then their ability to be able to participate in Senate Bill 123 if then, because before, so say you were presumptive prison, well, then you're not, it's very unlikely that you're going to be sentenced to probation, so you wouldn't be included in the group of people eligible for Senate Bill 123 treatment. So essentially, that statute is just updated to make sure that these people who now have a stronger possibility of being sentenced to probation would be able to participate in that drug treatment.
All right. Any other questions, committee? Oh, Representative Wheeler.
I just want to make sure that I clarify in my mind, as opposed to somebody else's, of course. Participate in the drug rehabilitation program. To get into the border box and the presumptive probation does not require that they participate, as I understand.
Well, and I should say you're sentenced to participate in that treatment. So what's going to happen is the judge is going to say, yes, you're sentenced to probation, but that probation is actually a sentence to the Senate Bill 123 treatment program.
And should they refuse or fail, they're still in the lighter sentence box.
Well, Scott will probably be able to speak to this better than I would be, but I suspect that their probation would be revoked because they would have to be in compliance with the terms of that program because they're sentenced to that program.
Okay, thank you very much.
Thank you. All right, seeing no other questions, thank you, Natalie. We'll go ahead and welcome Scott Schultz up, Executive Director of the Kansas Sentencing Commission. Welcome, Scott.
Thank you, Mr. Chairman, members of the committee. Glad to be with you today. Thank you very much for allowing this hearing and this opportunity to share with you. As what Representative Rissman has talked about already, this is essentially a redo on House Bill 2146 that you passed out favorably last year. I kind of want to go back just a little bit and talk about our current status. And as I told you a couple weeks ago when I was here about everything that the Sentencing Commission does, We're what I call the gatekeepers of the sentencing guidelines. And our commission is, that's what our charge is to look after the guidelines, make sure that they're maintained in a way over the years that evolution actually occurs in sentencing, and it's our job to actually bring recommendations to you. So where we sit right now and what we look at normally are providing reform efforts to you when we have prison capacity issues. What we have right now is normally our prison capacity, and Randy back here can tell you in the back, is 10,364. That's our capacity for male and female, okay? That would be in a normal context. Our population right now is about 2,000 down from that. However, as I indicated to you before, we also now have a new variable that the Secretary has added, and that is staffing capacity. It's currently at 8,503. So essentially, we are at capacity. We're only a couple hundred. So this is one of the things that the Sentencing Commission certainly would like you to seriously look at in a situation where it may look like, hey, we've got 2,000 beds to deal with. We don't. We're right at capacity with that staffing capacity. I also would like to ask you to consider the fact that what prison actually is and what is for. Prison is under the guidelines, is reserved for those most serious offenders, kind of like some of the folks we were just talking about in the previous bill. And that is something that there is give and take that happens in the system all the time. And then with legislation too, certainly, to be honest, in all candor with you. So what we're looking at in that particular bill, for example, we're looking at 43 beds that if you pass that legislation, all the way up to within 10 years, you'll need 215 extra beds to actually fund that particular bill. This particular bill actually saves 110 beds. So as I said, there's some give and take here in this situation, and this is one of those reform efforts that just plain makes sense. The drug grid was created in the early 1990s. If you could remember back then, we were in the age of Nancy Reagan telling us, just say no to drugs. The war on drugs had just started, and the legislature approved a drug grid that has all these months in it that were arbitrary. And if you look at the non-drug grid and the drug grid, you can see that there's some disparities in those, even in the possession context. And so that's one of the things that the Sentencing Commission has been looking at in a proportionality standpoint. The Reform Commission has also done the same thing in looking at how do we get some of these drug crimes to be proportional with some of the other penalties with regard to those non-drug crimes. And so I wanted to talk a little bit before I jumped into this about, again, about what that means on the guidelines. And we talked about this briefly too, of course. The white spots, of course, here, presumptive prison. Blue spots, presumptive imprisonment boxes or border boxes. In those cases, judge can basically say, you go to prison, or you don't go to prison. And it's not a departure from the guidelines. And then, of course, the green parts are presumptive probation. What the bill is doing is moving those around on the drug grid. And we'll kind of talk about that in just a little bit. I was trying to look, in preparing for this, trying to think a little bit about how to try and better articulate this to you. And to me, it kind of comes down to, say, for example, you're at home and your lights keep flickering on and off. They go off for a time period, and your family start complaining that, hey, why isn't our lights on most of the day? What are you normally going to do? You're going to call an electrician probably. So you might call 1, 2, you might call 3 to get bids on what's going on with your electricity. They come out, they take a look at it, they tell you based upon their training and experience just exactly what they believe. Lo and behold, all 3 of them say the exact same thing. You need you need to change a breaker or something on your breaker box. But they all say the same thing. What would you normally do in those situations? You probably would go with that electrician, one of the three, and have them go ahead and fix it. In this particular situation, I kind of liken that to this situation. You have the Joint Committee on Corrections and Juvenile Justice Oversight, of which the chair, Representative Heiberger, Representative Resman, and Representative Smith were all members of, recommending this particular bill for passage. You have the Kansas Criminal Justice Reform Commission that looked at this for 3 years and has recommended this particular bill to you. And you have the Sentencing Commission that for the last several years has also recommended it. These are individuals that are legislators. These are individuals that are judges, that are prosecutors. We have law enforcement on the Reform Commission that recommended this, as well as other attorneys, probation officers, that were all involved in this, that are boots on the ground, essentially, to make recommendations to you on this. So keeping that in mind, the exact bill itself is, there are 3 things going on here. The first is on that drug level 5, like what we had talked about, the least severe. These are possession crimes. My colleague Ed Klump will tell you that obviously that there are other crimes that are drug level 5s. What I would tell you is we have absolutely no convictions of those particular crimes outside of possessions. So, that's as of last year. I think we had three or 5 the year before, all of which received probation. So what we are doing are changing the number of months on there. Again, that was a result of the commissions looking at proportionality and looking at severity level 8 on your non-drug grid, and they decided that looks pretty close. What happened during the interim as far as last year, this bill was amended to actually make the penalties a little bit stronger. But at the end of the day, agreement between the parties was reached so that we could actually move the bill forward. And so that was the amended version, again, is what you're seeing in this particular bill. That is, I've kind of put a visual history on the attachment in my testimony, and that kind of gives you an idea of kind of the historical maturation of actually from what the current to the proposed and now the amendment actually is. So between that and the next provision is moving those grid boxes to a point where they make sense. And why do they make sense? Because as you can see in my testimony, we look at those grid boxes that we're proposing to change to border boxes from presumptive prison boxes, and then the border boxes to presumptive probation boxes. All of those were those that are the presumptive prison boxes. One would think if you fall in the presumptive prison box, you're going to prison, right? With the drug grid, it's a little bit different, and it has been for many, many years. The parties to the action, prosecutor, defendant, defense attorney, and the judge, over the years have made sentencing practice different on the drug grid. And what I mean by that is what you can see in the pie charts that I've put in my testimony, those folks in the 5A, 5B, 5C, 5D categories, instead of being sentenced to 100% of the time presumptive prison, they're only being sentenced 19.7% of the time to prison. Similarly, on your level 4 offenses, which are small drug sales, they are being sentenced at a rate of not 100, not 90, not 80% of presumptive prison times, 7.7%. So all that this bill is doing is actually modifying the grid to what current sentencing practice is doing. And that is essentially the realities of what are happening with this should be reflected in what current sentencing practice is. Otherwise, all the parties have to come before the court. They have to file departure motions. They all have to agree, which normally happens. Most of the departure motions that are done are all downward departures because the parties are wanting that particular part. Either they're going from a presumptive prison to a presumptive probation, or they're reducing the amount of sentence from X number of months to X number of months. So this is, you get a combination on this bill of both reducing the sentence on level 5s and then moving the grid boxes or the presumptive and border boxes around on the drug grid again. The third item is expansion of the 123 program. There is, obviously, there is sufficient evidence that offering Senate Bill 123 Substance Abuse Treatment Program to more folks is going to be more helpful and beneficial to them than actually placing them in prison. This is why we are adding mandatory treatment for 5A and 5B, as well as discretionary treatment for the 3Gs, 3H, 3I, 4C, and 4Ds. Keep in mind, if the court decides in those instances that public safety is not warranted to let these individuals be on Senate Bill 123 and be supervised by community corrections, that is a decision the court can make. If there is a threat, then the court can actually do that at the district court level. So the expansion itself does not include manufacture crimes. So somebody that's manufacturing drugs is not going to be eligible in this situation. As I indicated before, it certainly is not mandatory. There is a fiscal note of about $265,000. I've looked over our budget, and the commission administers the 123 program, and we certainly can absorb that cost with our current appropriations. So that should not be a stumbling block as far as passage of the bill. Again, as I indicated, there's 110 bed savings that the commission has indicated, up to 160. That is something that, again, we're asking you to agree with your electrician. That's what we're asking you to do. We're asking you to listen to what the professionals on all of these three committees are saying and to pass it favorably. I'd stand for questions at the appropriate time.
Thank you, Scott. Committee questions for Scott. And Representative Smith.
Thank you, Mr. Chair. Two things. First of all, I am a member on that committee now. I was not at the time this was sent out. I just want to make sure. You didn't say that, but I wanted to make sure that was clear.
And I apologize.
No, that's okay. The other part of it is, you know what I bring up every time you bring this to us, and I'm glad you brought these numbers to us because I see an anomaly I'm sure you're aware of as well. And that is, for those who aren't real schooled up on this, which is more severe, level 4 or level 5?
Level 4s are more severe.
Level 4 is more severe. And so we would presume that the more severe crimes would see prison more often. Instead, what we see here is almost exactly 4 times the number of level 5 crimes that people are in prison or actually charged with. Let me look at that. To be sentenced to prison. The reality is of 836 severity level 5 offenders, only 19.7, almost 20%. Then you look at level 4, less than 8% get sent to prison. What do you reckon is going on there? Why 20% of level 5 going to prison and only less than 8 going to on a level 4?
Representative, that's a great question. As you know, as we spoke and you were privy to last bill that was discussed, there are special rules. And there is a special rule that actually pertains to a third-time possession offense that is automatic prison. So no matter where you are on the grid, if you've had those 3 felonies, you're going you're in a presumptive prison range. We don't necessarily have that in that. That could be possibly one, other than the sheer numbers. Certainly, and I don't dispute at all that there are distribution sale cases that get pled down to possession. And so that's just the nature of the beast as far as plea negotiations is concerned. Very much possible that, or likely, that those individuals are pleading to possession charges and having to do prison time as a result of that. So those are but two of the potential circumstances that could exist.
And the executive director and I have had this conversation almost every time on this, just to make sure that the committee members are aware that one of the things we need to look at, and I'm just going to pontificate a little bit on that, is that when we see these level 5 and level 4 drug severity level sentences, we need to be aware that there are circumstances where individuals have committed much more severe crimes and pled down to those and are doing prison time as a part of that negotiation. Thank you.
Thank you. Additional questions, committee? All right, seeing none. Thank you very much, Scott.
Mr. Chair.
We'll now be pleased to hear from Randall Bowman with Kansas Department of Corrections. Sat in the far back corner today, Randy.
Mr. Chairman, members of the committee, thanks for the opportunity today. Yeah, sorry it's in the clear back corner, but I didn't want to sit up front. Again, I'm Randy Bowman, the Executive Director of Public Affairs for Kansas Department of Corrections. Thank you for the opportunity to appear briefly before you today on this bill. I won't read my testimony either, but just make a few additional comments to this. So we do support this bill. If you don't recall, just remind you that Secretary Zambuda serves on the Kansas Sentencing Commission, so he's had opportunity to be part of the expertise in developing these proposals, and he was an ex officio member of the Criminal Justice Reform Commission. So he's been active in both of these, and we support this as an organization. For you to have more tools in your toolbox as policymakers to manage the prison population and the associated costs, we think is a very important thing. So just like Scott kind of touched upon, and I listened to the testimony on the prior bill, you take X number of bills through this legislature every year, and some of them send more people to prison. Occasionally, there's been a reform bill to send a few less, so this is an opportunity to do that. Does it ever balance out? Probably not. As you can see in my testimony, you look back over the last 20 years, pre the pandemic that Scott talked about, we went from 8,000 in prison to 10,000 in prison. That growth just seems to have been natural in Kansas. You can go back into the 80s, you can go back into the 70s. We just somehow incarcerate more and more people across time. So anytime this body and the legislature as a whole could take into consideration means to manage that differently, within the expertise that is out there in the system, to realize that some populations can be managed very effectively, very successfully from a public safety standpoint in the community, that's probably an option you want to consider. Second point I just kind of highlight in there, it's in the testimony a little bit, but we shouldn't lose sight of as we do these things that a shift out of a prison bed onto community corrections is still a person in the criminal justice system that needs to be supervised and managed. So there is a need to keep that in front of us, that we make sure we look at those resources. So that's kind of why to us this is kind of a net kind of bill. Might spend a little less on prison beds if you don't pass a whole bunch of other laws that actually increase our population, and I imagine you might this session. And then look at the community correction side as well, that it's kind of a spend a little here or spend a little there, but it's about a net kind of deal from our perspective on that. So with that, I definitely stand for questions at the appropriate time. Members of the committee, and Mr. Chairman, thank you.
Yeah, certainly, thank you. Committee questions for Mr. Bowman? All right, nope. Representative French.
Thank you, Mr. Chairman, and thank you, Mr. Bowman, for being here. Can you give us any estimate of the percentage of your current residents in the prisons that are Category 4 and 5 drug-related crimes?
Mr. Chairman, Representative Mitch, I cannot. I could probably pull Scott's data. We really rely on their data. We don't typically calculate those kinds of figures. We rely on the Sentencing Commission data.
Okay.
So maybe Scott will know.
Thank you.
Sure, sir.
Thank you. All right, thank you, Mr. Bowman.
You all.
We'll now hear from Jennifer Roth with the Kansas Association of Criminal Defense Lawyers.
Hi, Sorry, I've got a new hearing aid and it gets tangled up in my mask. My name's Jennifer Roth, and I am here today as a proponent of this bill on behalf of the Kansas Association of Criminal Defense Lawyers. In my written testimony, you'll see I kind of went on the defensive, and it seems like maybe I didn't need to because it's my understanding that there aren't any opponents to this, public opponents anyway, to this bill. And as Scott pointed out, this is actually what you've already passed out. It's actually what the Reform Commission has recommended as well as the Sentencing Commission. So to me, that speaks volumes, and that's one of the reasons that we support it. But I just wanted to make a couple of points that aren't really in my written testimony. And the first one is to echo something that Scott just said, which I think about every day because in my work I look at the grid every day, which is that the number in the numbers in our grid boxes. Well, let me back up. First of all, as Scott mentioned, we've had sentencing guidelines for a long time. In fact, next year they're going to turn 30 years old. That's how long we will have had grids. And granted, some of the numbers in those have changed, but we've had these grids for 30 years. And the numbers in those boxes are arbitrary. It's not like there was some research. It's not like there's some research that says if you lock somebody up for 42 months, I think that's the high number in the 5A box. It's not like there's research that we can point to that says locking somebody up for 42 months or 18 months or whatever, this is the good it's going to do them, et cetera. These numbers are arbitrary. And I think about that every day. And so this idea that we're going to reduce a couple of them by a few months, just know you're starting from something that is, at its essence, arbitrary. So just keep that. I just wanted to make that kind of echo what Scott said. The other thing I just wanted to point out is that, you know, part of what this bill addresses is level 3 crimes. And when you look at the drug grid, which I do include at the back of my testimony because it helps me to be able to see these things at the same time. So in my testimony, the bottom grid is what you're looking at doing, and the top grid is what exists. And so it sounds like a lot, right, to say you want us to make a change that applies to level 3? That's like the second highest up from the bottom distribution charge. And I just want you to kind of put those numbers in perspective. So for example, the lowest level, and these numbers come from these numbers are about 10 years old too. They came from a bill when the grid went to 5 levels. But for example, the level 4, you can get the lowest amount there is so low, it doesn't even trigger a drug tax stamp charge. The next level, so for example, a level 3 possession with intent to distribute or actual distribution is 1 gram of meth, which I was back there Googling the street value of that, and some place said it was 20 to 40, some place said it was 80. But what I'm saying is that I think sometimes we picture in our minds that these amounts are huge, that there's a lot of money involved, that these are sophisticated dealers, and that's not the case. In fact, one thing that the committee, the RECOD committee that kind of helped inform this 5-level drug grid, during their meetings, they even talked about this notion that people who are drug users often do these small sales or things like that to fuel their own habit. And so I guess the point I'm trying to make here is that it may seem like, oh my gosh, level 3. Just know that those amounts are not actually that large. It's the way our grid is structured. So we're not talking about maybe the mental image we have of some of the people. We're talking about people who are likely to be users and need the treatment that Scott discussed and the chance that Scott discussed. I guess my last point that I would make is I've been in this committee and heard people from all over, asking for all different kinds of things, say, bed impact shouldn't be your only concern, which I agree. I mean, that is true. You should be concerned also about what's the good public policy. And the benefit you have here with this bill is that you get to do all the above. Not only does it reduce the number of beds that are required in prison, which can alleviate some of the stress on the staffing or allow you to put people who are in fact serious, commit serious offenses in those places instead. But you also have research and data that's telling you that this is the way that we should handle people convicted of these offenses. And so, again, you don't have to consider just the bed impact. This actually gives you the bonus of having that and being good public policy. So we support this bill, and I'm happy to answer any questions.
Thank you, Jennifer. Committee, any questions for Jennifer? All right, seeing none, thank you very much. We're now pleased to hear from Patrick Armstrong, Project Manager, Council of State Governments through WebEx. Welcome, Patrick.
How are you, Chairman Owens? Can you hear me okay?
Wonderful, can hear you great, thank you.
Perfect. Well, thank you for having allowing folks to speak on behalf of this bill today, Chairman and the members of the committee. And thank you as well, Chairman Owens, for your work on the Criminal Justice Reform Commission and leadership on that body. For folks who don't know me, my name is Patrick Armstrong. I work with the Council of State Governments, and our organization is a nonpartisan, nonprofit national organization, and we work in states across the country, and I think actually we have staff working in every state currently, and I've been working in Kansas for the last 2.5, 3 years since right before the start of the Reform Commission. And the work of that commission, from our perspective, has been very beneficial and positive because the focus has never been around that idea of just reducing prison beds or focusing on who's in or who's out of the prison population. Instead, that commission was focused mostly on the safety of Kansans and making sure that addiction was something that was dealt with and addressed with. And we heard over the 2.5, 3 years of us doing this work from judges, district and county attorneys, law enforcement, and others about people with addiction, and the fact that folks on the law enforcement side and in the courts see the same people over and over again. Folks with addiction have a challenging time recovering from that, and what all the folks in the system recognized was that in order to have a real impact, those types of folks that are clearly addicts and clearly in need of help, those folks need the opportunity to go to what you all have in Kansas as SB 123 treatment. And the conversation around the drug grid in the Reform Commission was centered around how does Kansas make a change that makes sense for what y'all are doing in the state and for that population. So our organization, what we were able to provide is data analysis of the court data that Scott Schultz and the Sentencing Commission have. Thankfully, we have staff that can look at the data in different type of ways, and that is normally what we bring to states. And we were able to look at those sentencing practices that Scott alluded to earlier, and that judges oftentimes, the populations that we're talking about where the changes are on the grid, they're already sending those folks to prison. And Scott walked through it. He explained that, they're already sending those folks to probation. And Scott walked through that in saying that in order to do what they're already doing now, the parties have to get together, they have to have additional findings, there's an extra step involved, and the grid changes are a way to allow the system to continue to do what it's already doing for that addicted population, but make it happen a little bit easier. And from our perspective, we like to, when we come into states, do help recommend changes that will benefit public safety, but also fit for the state and the situation that they're in. And thankfully, judges, prosecutors, defense attorneys are already making sure these things happen. And the grid changes are a small tweak that helps move the state in the right direction. But my testimony touches on some of these things as well. And I have a grid in my testimony on page 4 that shows some of the percentages of who's going to prison and who's not. It's a grid that if it's in color on your document, it has blue and red boxes, but I wanted to include that in there in case folks were interested in the actual data that we use to come up with these recommendations. But happy to stand for questions at the appropriate time. Thank you.
Thank you very much, Patrick. Committee questions for Patrick? All right, seeing none, thank you very much for your time, sir.
Thank you.
All right, committee, is there anybody else that wishes to speak on behalf of this bill? Any other conferees we missed? All right, seeing none, we'll go ahead and close the hearing on House Bill 2673. Thank you all for your participation in that. And we do have two bills in about 12 minutes, so we'll see if we can't move through these as well. We're going to move into final action on House Bill 2634 that we heard yesterday and ask Natalie to give us a brief refresher.
Thank you, Mr. Chairman. House Bill 2634 would require defendants to execute a waiver of extradition proceedings as a condition of bond.
Very good. Thank you very much, Natalie. Committee, any questions for Natalie? All right, seeing none. Are there any amendments as it pertains to this bill? Seeing none. Do I have a motion as it relates to this bill? $2634.
Yeah. Okay, Mr. Chairman, I move that we pass HB 2634 favorably out of committee.
Very good. Do I have a second? Representative Wheeler is our second. Thank you very much. Committee discussion on this motion. Representative Heiberger.
Thank you, Mr. Chair. I've got some concerns about this bill. For one, it appears to require someone to waive a constitutional right in order to execute another one. And in section, Section 5, 2, anyway, on page 2, line 21, it requires the offender to acknowledge that such person shall not be released prior to trial in any other state pending extradition to Kansas. That's something that we can't guarantee because of operation of other state law. So it seems odd to have somebody certified to that. So given those things, I'm going to oppose the bill.
Understood. Additional questions or comments, committee? Seeing none, we'll let you go ahead and close.
I'm close.
All right, committee. All in favor of passing House Bill 2634 favorably for passage, say aye. Aye. All opposed, say no.
No.
Ayes have it. Thank you. And Representative Heiberger and Representative Carmichael wish to be recorded as no votes. Okay, moving on to House Bill 2674. Natalie, you want to give us an overview on that one?
Thank you, Mr. Chairman. House Bill 2674 would require a forfeiture of an appearance bond to be set aside in certain circumstances, including if a warrant is not issued, if it's not entered into the index in a timely fashion, and I can take any specific questions you guys have.
Very good. Committee questions? Does anybody have any amendments as it relates to this bill? All right. Do I have a motion as it relates to this bill?
Mr. Chair, if it please the committee, I move HB 2674 favorable for passage out of committee.
Very good. Do I have a second? Representative Resman. We have a motion and a second. Committee discussion on House Bill 2674. Representative Carmichael.
Thank you, Mr. Chairman. I would remind the committee that the testimony, I believe it was from Mr. Rolfs yesterday, was that even a one-day inadvertent delay by the clerk's office in the issuance of a warrant, or even so much as one day's delay beyond a 2-week deadline by a sheriff in entering the information in NCIC results in essence in the commercial bonds person being discharged on the bond. And that's not, first, we'd call it a forfeiture in the civil law, something that is in essence an arbitrary penalty, not really based upon any particular need or circumstance, just a rule that if you don't get it done, if the clerk messes up and doesn't get it done, or the sheriff's clerk who's entering stuff into NCIC for some reason doesn't get it done, then the bonds person has no further obligation to the court, has no obligation to locate the potentially violent defendant, and bring them to justice, and in essence, they get off the bond. And so while I understand if I were in the bail bonds business that I'd want a law like this, I don't think it's really in the interest of justice, and I don't think it's consistent with preservation of the public welfare, because it has the effect of taking away the very important role of a bondsperson in retrieving violent felons and bringing them back to court to account based upon ministerial errors by a clerk of a court, or even a failure of a judge to say bond forfeiture and then forget to say and arrest warrant, or a clerk who doesn't get the job done right on time, or a clerk who types in the wrong identification information into NCIC. So I don't think there's a crying need for this, and I think it has bad public safety implications. So I will be voting no. Thank you, Mr. Chair.
Representative Wheeler.
Thank you, Mr. Chair, and I too have somewhat struggled over this bill. With regard to the sheriff's deputy entering the warrant into NCIC requires that the bondsman actually make a written affirmative request that it be so entered, and yet that request goes to the sheriff's department when the civil proceeding itself is existing within the case itself in the courtroom. So there's really no parallel and a way for a judge to know that, and I'm hesitant to say this, but in many regards, I agree with Representative Carmichael. I think that this bill has considerable merit, that bondsmen are being unfairly treated, either advertently or inadvertently by courts or by somebody, by delaying things so that they can get the judgment on the bond forfeiture before they even agree to go, and I just find that deplorable. This bill is good in many forms, but it needs some work. And regrettably, I think for that purpose, I think I need to vote no.
Additional comments, committee. All right, seeing none. Representative Smith, are you ready to close? Or you want to have a little more discussion?
I'm just digesting what the previous representative had to say on this. I can't find the part there that requires that the bondsman make the request of the sheriff. And my understanding is that the sheriff is going to receive the warrants in the same way that they have in the past, and that this merely requires the court to issue a warrant on those others when there's a forfeiture, or if there's going to be a forfeiture of the bond, that a warrant also accompany that. I'm not sure that it requires that the bondsman be the one who initiate or be the catalyst on that. Natalie, can you help me with that?
Mr. Chairman, so if you look to line 10 of the bill, that's the part that does require, if a defendant fails to appear, then we are adding language that would require the court to issue a warrant for that defendant's arrest. I think what Representative Wheeler is talking about is the request that the bondsman has to make to the sheriff's office to input that warrant into the index. So that does have to be a written request by the bondsman to the sheriff in that district. Now, I do think there are some sheriff's offices that just do that automatically, and it's, but if that written request is not made, then that's when you get into whether the bond would be able to be set aside, the forfeiture of the bond.
Yeah, and I think the impetus behind the NCIC is that not all warrants are entered into NCIC. And when the bondsmen know that there's a defendant that has left the state, when a bondsman knows that there's a defendant that has left the state, having that in NCIC is an imperative. Because when they, as required by most state laws, required to interact with law enforcement, let them know they're there, show them their paperwork, law enforcement then needs to be able to type it in their computer and see that it's there. Even if, as we heard, that the arrest is effectuated by someone else, or that the requirement is that that defendant is then put in custody in that state, which does happen, having that in NCIC and recalling that the bondsman still ultimately pays all of that extradition cost as well, I think is where they were getting with the request to put it into NCIC if it's not already there.
Yeah, so I guess I saw that more of a safeguard, and I could be wrong on that, but more of a safeguard that if it had not been done, that it could be requested by the bondsman, but it's not a requirement that the bondsman, him or herself, requested, I think. Is that right?
Well, no, because the court and the sheriff could already have done that.
Right,
This is
right.
in the event that it's not there.
Right, that's what I'm saying, a safeguard. In case that hasn't occurred, the bondsman would then have an avenue to pursue to make sure that it gets put in there.
Right.
Before they, yeah, okay, all right. Well, that's what I had to add to it, if anybody had anything else.
Representative Wheeler.
I appreciate the comments. And perhaps it is not a big deal, but I have encountered deals like this that are big. In that the request is made by the bondsman to the sheriff to enter it into the NCIC when the bondsman knows that a person has fled the state and particularly knows where they are, if that's possible. The point being is that when it comes down for the court to decide, the court opens up its file, and there's no record in there that that request was made, because it's not filed with the court, it's filed with the sheriff. There's no requirement that the sheriff file that with the court. So now we have an evidentiary hearing as to whether or not it's a proper notice. And it's maybe minor to some, but it's not minor all the time.
So if the bondsman made the motion or the request to the court and then had the court direct the sheriff's department to enter it into NCIC, is that your thought?
That's my thought, with the obligation of the court to notify the sheriff or to order the sheriff.
Okay.
But that's what I'm saying. There are technical details in this that this is a basically fundamentally good bill, but I think there are some areas that could be addressed. And if people are willing to say, hey, this is good enough for me, I certainly understand, because there are many good areas to it.
Well, we could certainly, we've got a couple of options here. We can withdraw the motion, have an amendment drafted for tomorrow to discuss that amendment tomorrow. We could bring an amendment on the bill on the floor and discuss it there. I'm kind of open to options at this point as it relates to moving the bill forward, if that's the primary concern here. Representative Patton.
Thank you, Mr. Chair. My recommendation would be that we delay voting on it until tomorrow and get it fixed in committee instead of trying to hash this out on the floor with an amendment that will just confuse 120 other people or 115 other people who don't know exactly what we heard in committee.
Sounds good. I understand. Well, if that's the case, then
I'll withdraw my motion.
All right, very good. Withdraw the motion. Representative Wheeler, if you'll get with Natalie and get that drafted up, we'll bring it back up tomorrow for discussion. Aren't you glad we use email nowadays? All right, committee. We've got that one. We'll go ahead and move that to tomorrow's agenda. We'll continue this discussion and thank everybody for their work today. And with that, we'll be adjourned. Thank you.